गुड इवनिंग फ्रेंड्स। आई होप कि आप सभी सकुशल हो अपने परिवार के साथ। कोविड के बाद मुझे बहुत देर बाद चांस मिला है कि मैं आपको लाइव आके किसी टॉपिक पे सोशल इम्पोर्टेंस जो इंडिया में है उसके ऊपर एक लीगल पर्सपेक्टिव पे कुछ बोल सकूं जो कि आपके लिए हेल्पफुल हो। तो आज का टॉपिक मैंने सिलेक्ट किया है जुवेनाइल जस्टिस एक्ट। इट इज ए स्पेशल एक्ट meant for the juveniles. Before proceeding with the act, मैं आपको कुछ भारतीय संविधान के कॉन्स्टिट्यूशन के प्रोविजन से वाकिफ करवाना चाहूंगा। कॉन्स्टिट्यूशन संविधान के अलावा जो इंटरनेशनल प्रोविजंस हैं जो ऑब्लिगेटरी है इंडिया के लिए आफ्टर साइनिंग इट, जिसके तहत ये एक्ट बना, क्या चेंजेस आए और क्या प्रेजेंट स्टेटस है। तो स्टार्टिंग विद द कॉन्स्टिट्यूशन, आर्टिकल 15 क्लाउज 3 empowers the state government parliament to make special provision for the women and children irrespective of the fact that there is a provision of discrimination. Then article 39 directive principle says special provisions for the health and strength of the workers, men, women, and tender age of the children are not to be abused by whatsoever the reason, whether by the economic, social, or any other necessities unsuited to their strength and age. Then the in the same article 39, the constitution further says the opportunities and facilities to be given to the children so that they can develop in a healthy manner and conditions of the freedom and dignity and childhood and youth are protected against any exploitation, against moral and material abandonment. That means government, there is a directive principles which says government has to provide such facilities which results in the full development of a child. Then article 45 says provision for free and compulsory education. Article 47 imposes a duty upon the state, that state means parliament, any legislature or the government, to raise the level of the nutrition and standard of living and to provide improve the public health. Then comes the International Convention on the Rights of the Child. It was adopted by the General Assembly in 1990 and signed by the Government of India in 1992. The basic provisions for the full development of the child includes in the International Convention is the life survival and development, protection from violence, abuse and neglect, and education that enable the children to fulfill their potential, be raised by or in a relationship with their parents. They are free to express and they be listened to. Subsequently, two more provisions were added, that child below the 18 years of age are not to be recruited in the armed forces, and state to prohibit the prosecution of child pornography and sale of the children in slavery. In 2011, a third provision was also added to enable the child to directly complain to the United Nations under the obligation of the Constitution and the international provisions. Parliament of India enacted Juvenile Justice Care and Protection of Children Act 2000 which was subsequently amended to fill up the gaps due to the high pendency and other reasons. But in 2015, the whole new act was enacted, the Juvenile Justice Care and Protection of the Children Act 2015. Looking into the shortcomings of the previous act, this is a broad act covering each and every aspect related to child, whether it is related to the abandoned child, whether it relates to the adoption of the child, it relates to the proceedings before the court of law. There are the different child development authorities and functionaries at various levels. This act was also enacted facing some practical difficulty in 2016, 17, and 2021. This act has classified offences regarding the child only in three categories: heinous offences, serious offences, and petty offences. Heinous offences are where the punishment is more than 7 years, and serious offences where the punishment is between 3 to 7 years, and petty less than 3 years. As I said, it is a broad act covering different things. It has detailed the definitions regarding various provisions. The main thing to be known to the common man is what is the board. ये कॉमनली बोला जाता है, इट इज देयर आल्सो इन द एक्ट कि जो जुवेनाइल है, जुवेनाइल मींस एनी पर्सन बिलो द 18 इयर्स ऑफ एज। अगर कोई क्राइम करता है, ही और शी नोट टू बी लेबल्ड एज ए क्रिमिनल, ही इज नोन एज चाइल्ड इन कन्फ्लिक्ट विद लॉ। The term used is child in conflict with the law. That child who is in conflict with the law is not to be tried by normal court. There is a Juvenile Justice Board. As per the Act, it is a 3-member board consisting of judicial magistrate first class or metropolitan magistrate having at least experience of 3 years and 2 other social workers, one of whom shall be a woman. A woman member, a judicial member, that is a magistrate having a 3 years of experience, and any other third person. So these people, child in conflict with law, are tried by or before the board. Then there is also other court defined in the act itself, children court. Children court is a session court established under the special act POCSO, Protection of Children from the Sexual Offences Act 2012 and Protection of Child Rights Act 2005. These are the two types of courts. The general principles to be followed for the administration of this act is: the child is presumed to be innocent. The court or the board or any individual has to act in the best interest of the child. The act, whether committed by the child against the any penal provision, cannot be used to stigmatizing the act, stigmatizing the child. That means if any offense is committed by a child and after attaining the majority, if he or she applied for a police protection as normally seen if one goes to abroad or for the any job employment purposes, the police cannot report that crime whatsoever committed by the person when he or she was a juvenile. It works on the principle of the natural justice. The concept, the act of juvenile or the age can be agitated at any level. At the initial level, when produced before the board, if that is not known at the appellate stage, before the appellate court, divisional court, or even in the SLP before the Supreme Court. How to determine the age? This is a very controversial subject. It has been clarified in the act. एक्ट ने क्लियर किया है या तो स्कूल का सर्टिफिकेट या फिर म्युनिसिपैलिटी से जो बर्थ सर्टिफिकेट होता है दैट इज टू बी दैट आर द वैलिड प्रूफ ऑफ एज. अगर ये दोनों में से कोई अवेलेबल नहीं है देन मेडिकल एग्जामिनेशन ओसिफिकेशन टेस्ट. In the absence of school certificate and the birth certificate issued by the municipality or the panchayat whatsoever, the ossification test is to be determined. No other identity proof serve the purpose or can be used in the inquiry by any court or the board to determine the age. Then there is a very important provision in the act. If the child in conflict with law has been acquitted by the board or children's court, no appeal to be preferred. Then there is a controversy regarding the provisions of the bail. First, as soon as it is known to the prosecution, that is the police officer, that some child has committed a offense, it is to be noted, it is the duty of the police officer to inform the guardian parents or relative under whom care the child is that he has committed an offense, but he need not put in a jail behind the bars. He need not. Mandatory, he cannot be put in behind the bars. He has to be provided conducive environment. He has to be taken care by special police stations which are to be there in every district. Special police officers who are trained how to deal with the children. He has not to, the child in conflict is not to be placed along with the other criminals. As per the CRPC and as per this act, the child has to be produced before the magistrate or before the board, not magistrate, within the 24 hours from the time of arrest, excluding the time of travel. And the magistrate has to release the child in conflict with the law on bail, except that is bail can only be denied if the board comes to conclusion that if the child is released on the bail, he may come into some criminals, he may be exposed to moral, physical or psychological danger, which will defeat the purpose of releasing the child. Then there is also a controversy regarding the bail to be granted. Recently, Bombay High Court has concluded in a case that if the child is denied the anticipatory bail, it amounts to the contravention of the Article 14. I am not mentioning the name of the case because all the material regarding the child is to be kept confidential. The bail application number is 277 of 2022, decided by the Bombay High Court. The other important thing that is to be known to a common man or the society is, even if a child has committed a crime, no media whatsoever, social, print, electronic, has to disclose anything which result in the identification of a child. No court proceedings has to be reported by any media. This is to prevent the leakage. There is provision of punishment and fines. Then another thing, what sentence cannot be passed against a child? No child in conflict with the law shall be sentenced to death or life imprisonment, whatever the nature of the crime is, whether it may be heinous, severe, or petty. Further, no joint proceeding of a child in conflict with the law or any other major person in the same crime should be conducted. The child in conflict with law has to be dealt with or before the board only. The maximum punishment provided in the act is 3 years old. Then coming to the act, as I told, it is a very comprehensive act. The act contains provisions for the adoption. Adoption can be by any person, relative, or in any religion. It can be domestic adoption or as well as the international adoption, inter-country adoption. It may be by a single divorced or married couple. You need not to be married to adopt a child. Even a single person or divorced person can adopt. Single male is not eligible to adopt a girl child, but a single woman can adopt a male child. This is the provision somewhat in conflict with the Hindu Minority and Adoption Act, where a single male is also eligible to adopt a girl child. This act is applicable to every religion, irrespective of the customary law, irrespective of the special law. Even Hindu can adopt a child under this provision of this act. Muslim can adopt, Christian can adopt. The basic purpose of the adoption is restoration of the child to the parents whatsoever adopted for us, foster or the guardian or fit person. And the second most important thing provided in the adoption is the adopted child has to be kept with the siblings. That means two siblings are not to be separated for adoption. The two siblings can be adopted by a single prospective adoptive parents. There is requirement for compulsory registration by any institution, NGO dealing in children's. If it is not registered, then necessary action, legal or penal action may be taken. The maximum punishment provided is 3 years. There is a provision of appeal before the high court, before the district court, and revision is before the high court. So I will summarize for you. It is a very comprehensive act. Children is below 18 years of age. He need not to be brought before the magistrate. Anyone can agitate the age of juvenility before any forum, whether in appeal, trial, before the board, before the magistrate, and then that court has to inquire into the birth certificate issued by the school, or birth certificate issued by the municipality or the registrar, whether by panchayat, and school certificate are the two important documents that has to be looked into. If these are not available, then ossification test, disclosure of identity of child in conflict with law is prohibited. Maximum punishment provided is 3 years, but it can be enhanced depending upon the circumstances. But no capital punishment or life imprisonment till the end of the life. The main objective of the act is the reformation. In the adoption, two siblings can need not be separated. They effort should be made that both the siblings or any siblings can be adopted by a single adoptive parents, so that they may be kept together. Any NGO dealing in the children need to be registered within 6 months from its establishment. If anyone reports anything regarding to the child in conflict with law, there is a provision for punishment and fine. The children need to be arrested. Immediate requirement for the police officer is to inform the parents, guardian, to be produced before the board within 24 hours. So I hope this act has taken care of the major requirements as per the international obligation and constitution to deal with the child in conflict with the law. There is bail is the rule, except under certain circumstances. The child has a right to apply for the anticipatory bail as held by the Bombay High Court recently. So, with this, I end with the present session and wish you good and healthy life. Thank you very much.